Okay, when people talk about estate planning, they're probably thinking about a couple different documents, couple different things. So I just wanted to briefly touch on the most popular estate planning documents, some of which I'm sure you've heard about, some of which you maybe have not heard about. Just give a little bit of context, a little bit of detail for them so that if you're thinking about doing your estate plan, you know what you need, what you want, and what you maybe should have. The two basic ones, kind of what I call the cornerstone of any estate plan, is either going to be a trust or a last will and testament, right? And I talk about, the differences between the two in a bunch of different videos. So I won't go into too much detail with them here, but a will and a trust ultimately say who gets what of your stuff after you pass away, right? That's what most people think about. When you talk about estate planning, that's what most people are thinking about. Like, hey, when I die, who gets my house? Who gets my great grandfather's watch? Who do the cars go to? Who gets my bank account? All that sort of stuff. That's a will, and that could be a trust. It could be a combination of both. It could be one or the other. But that's really the cornerstone. And so the last will and testament, that's pretty standard. The will, when I mention a trust in this context of estate planning, which I think probably most everybody should have a trust, in very rare instances, what I say you don't need one, just have a will, very, very rare instances. What I'm talking about is what's called a revocable living trust. Now, if you're doing Google searches about trust, you're going to see an irrevocable trust, maybe a charity remainder trust, a credit shelter trust, a bunch of different stuff. It might just say a living trust. It might say a revocable living trust. Could say a bunch of different things, but typically, generally what I'm referring to is when you have a trust as your cornerstone, it's what we call a revocable living trust, a revocable trust, right? So you have those two, those are the two core components. Now, those are really what happened after you pass away. Now, that's not 100% true. The trust actually plays a very important role while you're still alive, whereas the will only comes into play after you die. But the other documents, we're going to call them health directives, healthcare directives, and these are what everybody need to have anyways. The three I'm going to mention here are going to be the power of attorney. And so the power of attorney, typically, what I would recommend is it's called a durable power of attorney. Durable meaning that it can be used in the event that you're incapacitated. And that's a document that really allows somebody to sign legal documents on your behalf if you're unable to, access financial records again if you're unable to, and basically operate as you while you're still alive in order to take care of your affairs. So typically we might see this when someone has Alzheimer's, dementia, they're incapacitated, they were in an accident, and you just can't do things on your own. Well, the power of attorney, hopefully you have that in place, and that gives the authority for somebody else to be able to do those things. One important thing about powers of attorney, though, is that once a person dies, the power of attorney is no longer valid. You can't use it anymore, which is why you need to have some of these other planning documents in place, like the trust, right? So power of attorney, durable power of attorney, that you should definitely have. Then you have what's called a healthcare power of attorney, also goes by designation of healthcare document. But this is specifically for medical concerns, medical decisions. So again, you have Alzheimer's, you have dementia, you're incapacitated, maybe you're undergoing surgery, something's going on and you can't communicate your medical wishes with the doctor. Well, the healthcare power of attorney in this document, you've specified who you've authorized to communicate and express those wishes. So again, very, very important. And then the last one of those healthcare directives is going to be the living will. Different from the last will and testament, a living will is essentially what I call the pull the plug document. Don't keep me on life support, right? And so this is specifically for end of life decisions. The physicians, the doctors have determined that you're not going to have any sort of meaningful life, that you're going to be in a vegetative state, that the only way to be kept alive is on life support. Well, the living will, you're signing, obviously when you have capacity to do so, that says, I don't want to be kept alive on life support, pull the plug. That's it. Now, the difference between the living will and the healthcare surrogate, the healthcare power of attorney, very similar, but often people don't want to let that decision be made by somebody else. So often, most people don't want to put their spouse or put their children in the position where they have to decide whether or not to pull the plug. So typically you would have a living will, if that's your wish, and the living will is going to supersede the healthcare decision. So basically, if a person is in this situation, the healthcare document is going to let their loved one make all types of medical decisions. What type of treatment do they want? Where do they want to be kept, et cetera, et cetera. But if it comes down to the point where they have to make the decision to keep them on life support or not, the living will, if you have that in place, is going to say, I've made my decision. I don't care what my loved one says. I don't want them to make that decision for me. I'm making the decision. I don't want to be kept on life support. So that's the next one, the living will, that we would typically include in that package. Now, there's other things that you might want to include. You might want to have a certificate of trust. I won't go too far into that. If you have a trust, obviously, you probably want to have something in place about, and these could be clauses in your other documents, but funeral versus cremation. Where do you want to be buried? Do you want to be cremated? What type of service? That type of stuff. That might be included. If you have children, you might need to you should name who you would want to be the legal guardians of your children should something happen to you. And you probably want to have just a list of important documents where you have all this stuff, where do you have bank accounts, passcodes to social media, to email, that sort of stuff. But those are probably the primary estate planning documents that everybody should have at some point and be reviewing them and updating them regularly.